Hello, everyone, and welcome to Criminal Investigations Taught Completely in an Online Format. Okay, so for many of you, I know this is probably the first time you've taken an online course, also known as a distance learning course. And I just want to be sure that you listen to the 15-minute tutorial that I sent out probably a week or two before the course began. I sent out an email to all my students. It had a 15-minute tutorial in there to help you kind of get an understanding of how we're going to do this. So please make sure you've listened to that tutorial. Super important. Okay? So assuming that you've listened to the tutorial, let's get right into the text. So just for clarity's sake, I am in the Hess, Orthman, and Cho Criminal Investigation text. I'm in the 11th edition, and we are in Chapter 9. Right, that's what we're starting out. Chapter 9, assault, domestic violence, stalking, and elder abuse. Right, all serious crimes in our society, no doubt. And if you look on page 315, there begins a story about the actress Sandra Bullock. Take a look at that. It's an interesting stalking story. But flip the page and go over to page 316. And I want to kind of give you a couple of reminders, little refreshers about some things that you probably already should know. Okay, so we're going to begin with kind of a recap. I hope that everyone remembers that there's 3 ways in the United States of America that we capture crime data, right? We capture crime data through the UCR, also known as the Uniform Crime Reports, which is essentially a compilation of police reports from the vast, vast majority of police departments in the country, not all, but the vast majority. Then we get it from NIBRS, the National Incident-Based Reporting System, which is kind of like a new and improved UCR. It expands the crime categories, etc., gives more information on each crime. And then, of course, the National Crime Victimization Survey, also known as the NCVS, which is administered by the Census Bureau every year and tries to get a sense of, among other things, the dark figure of crime, that is the crime that is unreported, right? Just a quick remembrance, the UCR, the Part 1 crimes are known as the 8 majors, also known as the index crimes. And what are the 8 majors? You have 4 against property, 4 against people, right? The 4 against people, the most heinous crime in a civilized society. You have murder, followed by forcible rape, followed by robbery, and then a felonious assault. The 4 against property, grand larceny auto, arson, and burglary, right? Okay. If you open up the course at this point, what you should find is a couple of handouts in Chapter 9, okay? Let me just hit my laptop here. There it goes, and it's coming to life. And the first handout I'd like you to take a look at are the 4 culpable mental states in the state of New York. You should know this already from Investigations 1, no doubt, and perhaps even from criminal law and even maybe con law, depending on who your teacher was. But what are they? They're intentionally, knowingly, recklessly, and with criminal negligence, right? And make sure you take a look at that handout. Make sure you understand what the 4 culpable mental states are, because as we move forward in Investigations 2 and we look at individual crimes, understanding culpability, understanding intent, and knowingly and recklessly and with criminal negligence is going to be an important factor, right? So make sure you take a look at that. Also, too, you want to open up the handout. Let me just pull it up for Article 120, the New York State Penal Law Assault handout. And let me just open up mine. And if you can open it up for a minute, and why don't you just pause this and go open it up and then come back and you can listen to me. All right, how's that? Okay, so I'm assuming that you opened up the Article 120 assault handout. And a couple of things I want you to take a look at, first of all, is that you have assault in the 3rd degree, right? Assault in the 3rd degree is known as misdemeanor assault in New York, or simple assault. We also call it simple assault, right? And when you get up to 120.05, section 120.05, assault in the 2nd degree, now you're getting into felonious assault, right? Also known in some circles as aggravated assault, right? two things I want to bring to your attention right away. You'll notice, and I have them highlighted in yellow, or they should be highlighted in yellow, I think, on the handout. I'm pretty sure they are. But you'll see that when it comes to assault in New York State, and by the way, we're dealing with New York State law in this entire course. We are not going to delve into the kind of national, bland, generalized understanding of the law sometimes that the text presents us with. We're not going to study that. Why study that? We're in New York. The vast majority of you, I think, are going to go on to study some type of law in New York. We're going to stick with New York law. I think it's the most germane to what we are doing. So, by the way, take a look again, and you'll see at Assault 120, you'll see in that they use terms like cause physical injury. And then if you look down below in assault in the second degree, it says cause serious physical injury, right? So the first thing to kind of understand about assault in the state of New York is that you always have to have an injury in the state of New York for the crime to be an assault. In some states, that's not the way it is. In some states, merely threatening people is an assault, but that's not the way it is in New York. In New York, in order to charge someone with assault, whether it's a simple assault or a felonious assault, there has to be an injury. And obviously, there's a difference between what we call PI, physical injury, and SPI, serious physical injury. And that obviously is the seriousness of it, right? So make sure we get this as we're moving forward. You could take a look at this handout. This is right out of the New York State Penal Law, as is the Culpable Mental States handout. It's right out of the Penal Law. And there's a whole bunch of different assaults in there, taking you through simple assault to felonious assault in the second degree, assault on a peace officer, police officer, assault in the first degree. And so there's a bunch of things there you can take a look at. And as always, when you're doing this course, if you have any questions, you can always put them on the discussion boards, also called the blog. You can put it on the blog or the discussion board, and I or one of your classmates will certainly try to answer it if we can, and that will help you for sure. All right? Okay, so now that we've done with our review of UCR, NIBRIS, and the NCVS, the 8 majors, the Part 1 crimes, the index crimes, the culpable mental states, the Assault 120, and the penal law, right? Oh, by the way, one more thing about the assault. If you take a look, right, you'll see the culpable mental states in assault. So, for example, if you go right to the first one, assault in the third degree, right, you see subdivision 1 is intentional. Subdivision 2 is recklessly. Subdivision 3 is with criminal negligence, right? And then if you go down to assault in the second degree, you see something similar. You see them using intent. You see them using recklessly, right? And so this is why it's important to understand what the difference is between the culpable mental states when you're reading the law. It really is important. Let's just take a look at top of page 317, learning outcome 1 in the blue box. It says, assault is unlawfully threatening to harm another person, actually harming another person, or attempting unsuccessfully to do it. Well, as I said a few minutes ago, that's not true in New York, because in New York, assault is actually harming someone or trying to harm someone, right? It is not threatening to harm them. So that's not, in New York, threatening to harm someone is a different offense, right? It's not assault, right? In assault, you must have an injury, you must have harm. Obviously, you can have an attempted assault, and we'll talk about that in a few minutes, right? Look at page 317 on the left, right? And there is right underneath that blue box, 2 paragraphs down, you see the word battery is in bold. It says actual physical contact is not required for assault. That, again, is wrong. And you're going to see this time and time again. It's wrong because it's not speaking to New York state law, and we are, right? Let's go down to classification. It says assaults are classified as either simple or aggravated, and another word for aggravated assault in most circles is the word felonious, and that is true even in New York. And going up to the top of page 317, right above the heading legal force, the last sentence talks about the clearance rates. Now, I want to talk about this. First of all, that whole paragraph with clearances in it is super important. Let's refresh our memories. In the United States of America, there's two ways that investigators clear a case. Only two ways. Maybe you remember this. If you took me, you certainly should, right? One is by arrest of any one perpetrator. And number two, the second way to clear a case is through what we call exceptional means, also known as an exceptional clearance. And an exceptional clearance is when the perpetrator's identity is known, but for reasons beyond law enforcement's control, they cannot bring that person to justice. And some examples of exceptional clearances are: the perpetrator is deceased. The perpetrator is incarcerated for a long, long period of time, and it doesn't make sense to bring charges against them, right? They're doing 25 to life for something else, right? Or the perpetrator has fled to a country that does not have an extradition treaty with the United States. And so in that particular example, we take a clearance, an EC, an exceptional clearance on that case. Just make sure you understand something. I always get from students when I ask them I say there's two ways to clear a case. What are they? And they say right away, they say an arrest, right? An arrest of any one perpetrator. Yeah, if there's 9 perps and you arrest one of them, that case is cleared. If there's 10 perps and you arrest one of them, that case is cleared, right? And then they say, to explain, instead of saying exceptional clearance, they say, the perp fled to a country and you can't bring him back because they don't have an extradition treaty. That is an example of an exceptional clearance. It's not the definition of exceptional clearance. Exceptional clearance is a clearance. A case is cleared by exceptional clearance when the identity of the perpetrator is known, but for circumstances beyond law enforcement's control, they cannot bring that person to justice. And we just went through some examples, right? So if you look in this paragraph that flows from the bottom of 317 up to the top of 317, there's a whole bunch of data in there, right? It's good stuff. But the last sentence says the clearance rate for aggravated assault was 57.7% in 2013. Now, in 2009, if you have the older book, it's 56.8. So both times, 57.7, 56.8, you're talking about a high clearance rate. Yes, that is a high clearance rate. That means more than half of all of the felonious assaults, that's aggravated assault, in the U.S. in 2013, more than half of them resulted in someone either being arrested or an exceptional clearance, right? That's what it means. And that is high. Over 50% in any crime is a very good clearance rate. It's something to be proud of. And I often say to my students, well, why do you think it's so high? Why do you think the clearance rate for aggravated, meaning felonious assault, is so high? And the short answer is victim-offender relationship. And you ought to remember VOR from my class if you've had me before. If not, it's discussed in other classes. But when you're dealing with certain crimes, victim-offender relationship becomes critically important, meaning that the victim and the bad guy know one another somehow, right? So what crimes have high victim-offender relationships, meaning there is a high likelihood that they're going to know one another? Well, homicide, murder, believe it or not, has a high VOR. And absolutely positively, domestic violence, assault, these are crimes generally that have high VORs. Robbery, on the other hand, not so high. Forcible rape, yes, pretty high VOR. Again, VOR, victim-offender relationship, meaning the perpetrator and the victim know one another on some level. And, of course, that makes a crime easier to solve. If I know who did this to me, then it certainly should be easier for the police to solve the crime, right? All right, let's take a look at legal force on page 317. It says physical force, I'm reading right from the text, may be used legally in certain instances without it being considered an assault. And then it gives you examples about teachers, people operating public conveyances. They mean like bus drivers and things like that, law enforcement, right? And then it talks about teachers have the authority of in loco parentis, meaning in place of the parent. And in many states, teachers are allowed to use minimum force to maintain discipline, stop fights, prevent the destruction of school property, blah, blah, blah. And it goes on to tell us who are some other people who are empowered to use force legally. And of course, we know intuitively that cops, corrections officers, probation officers, parole officers, all of those positions are empowered to use force legally, provided it is within reason, right? Provided it's within reason. Let's go down to elements of the crime, the bottom of page 317. I hope you remember this, right? Every crime has elements. Every crime has elements, right? And the elements usually involve a mens rea and an actus reus. Does this sound familiar? Right? So what's the mens rea? Well, the mens rea is the culpable mental state of the person committing the crime, right? It's their mindset at the time of the crime, what they were, the bad guy. And what's the actus reus? It's the actual act that they did that is illegal. So, for example, and I always use this example when I'm teaching elements of the crime and mens rea and actus reus to my students, in New York State, one of the burglary statutes says a person is guilty of burglary in the third degree when they enter or remain unlawfully in a building with the intent to commit a crime therein. Listen, I'm going to say it again. In New York State, burglary 3, a person is guilty of burglary in the third degree when they enter or remain unlawfully in a building to commit a crime therein. Here you have the elements of the crime. There are two elements in that crime. There's the actus reus and the mens rea. The mens rea, the mind, just remember the M is the mind, that's easy. It says with the intent to commit a crime therein. Therefore, the mens rea is the intent of the burglar to commit a crime therein. The actus reus is the act, and that is to enter or remain unlawfully in a building, right? And of course, when you're a prosecutor and you charge someone with a crime, you have to prove all of the elements of that crime beyond a reasonable doubt in order to get a conviction, or if it goes to trial, right? By the way, there are some crimes, if you should remember this too, that do not have mens rea. They just have an actus reus. They don't care what you were thinking at the time you did it. They just know that you did it. For example, unlawful possession of a weapon, right? The New York State Penal Law will say something like a person is guilty of criminal possession of a weapon in the 5th degree when they unlawfully possess a firearm, right? You didn't hear anything about a mental state. You didn't hear anything about a mindset of the bad guy. So there are crimes that just have the actus reus. They don't have a mens rea. Crimes that don't have a mens rea, that only have an actus reus, are known as strict liability offenses. Strict liability offenses. That's what they are known as. And where do we find them in the penal law? A lot of low-level narcotic offenses are strict liability. All they care about is that you possess the drugs. They don't care what you were thinking. You're guilty. Low-level weapons possession. All they cared about is you possess the guns. They don't care what you were thinking. You're guilty, right? And those are two very good examples of strict liability offenses. Speeding, by the way, is a strict liability offense in the vehicle and traffic law, right? No one cares what you were thinking, right? No one cares what you were thinking. The speed limit was 65. You were going 75. You're guilty, right? On the other hand, reckless driving speaks about your reckless mental state. That is not a strict liability offense, right? Hope it makes sense. Again, if it doesn't, you reach out to me on the blog and post a question to the blog, or also known as the discussion board, and we'll make sure we straighten it out for you, right? By the way, bottom of page 317, they discuss simple assaults, right? A simple assault is essentially what it means and what it sounds like, right? Like in the state of New York, when we talk about simple assault, we're basically talking about assault in the 3rd degree, which is a misdemeanor, and it usually involves only a little bit of an injury, right? And ordinarily, no weapon. But if you read that statute carefully, you might find a weapon in there. So you take a look at that law. All right, let's flip to page 318. We're going to skip this stuff on the left-hand side in red, in the red bold, because that's not New York law. All right, we're going to go down to aggravated assault, and the only thing I'm going to remind you in this little part right here is that aggravated assault for our purposes is the same as felony assault, right? Just remember that. And then if we go to the other side of page 318, we see attempted assault. An attempted assault means the act was not completed, right? The bad guy tried to do it, but he or she did not complete it. Offenses that are incomplete, that is, they did not go to completion, are known as inchoate offenses. And I'm going to spell that for you. INCHOATE. Inchoate offenses. INCHOATE. Any crime that is attempted, that is not completed, right? Attempted robbery, attempted assault, attempted burglary, attempted rape. All of those attempted crimes are called inchoate offenses because they were not completed. Going over to page 319, I'm going to read right from the text. It says special challenges in investigation, right? It says sometimes in an assault investigation, it is difficult to distinguish the victim from the suspect or to know who started a fight. Both parties may claim the other person struck the first blow. In such cases, both might be charged with disturbing the peace or disorderly conduct or assault, depending on the state and statute, until officers can obtain more information. By the way, when you walk into a bar and there's two people who have basically beat one another up, and you wind up arresting them both, we have a term for that. We call it cross complaints, right? Cross complaints. Just hold your two fingers up like you're making an X, and that's why we call it cross complaints, because essentially each party who's been beat up is charging the other party with beating them up, right? That happens sometimes when the police can't figure out who the aggressor was, or they can't figure out who the victim is, or they can't figure out who the winner is, or they can't figure out who the loser is. Then you wind up taking both parties into custody and charging them both. Again, that's called cross complaints, right? It says, it is also necessary to determine whether the altercation is a civil or criminal matter. Yeah, that's always true in police work, right? You roll up, and one of the first things you're trying to figure out is, do you have a criminal matter? Because if you have a criminal matter, then it comes under the purview of the police, right? But if it's a civil matter, then it's not under the purview of police, right? And the next line says, a person who accidentally injures someone is not guilty of a criminal offense, but may be sued in civil court by the victim. Well, that's debatable, because think about what criminal negligence means, right? Criminal negligence essentially means kind of like accidentally. Essentially. I don't want to make it too simple, right? Next paragraph says, it is sometimes difficult, especially in cases of wife and child beating, to obtain a complaint from the victim. If it is a simple assault, which is a misdemeanor, you must see the offense committed. That's not true in the state of New York. Let me explain. And the reason why I'm reading it is so that you don't read it and then get confused. In the state of New York, if officers have probable cause to believe that a misdemeanor or felony was committed, they have the right to make an arrest, right? And that's an abbreviated version of the arrest laws, right? But essentially, if you have probable cause to believe that a misdemeanor or a felony has been committed, you can arrest somebody, right? You're on duty, you're in your geographical area of employment, you can arrest them, right? In New York, a violation of law, which is lower than a misdemeanor, right? You have violations, then they bump up to misdemeanors, and then they bump up to felonies. Violations of law ordinarily have to be witnessed by an officer. But assault in the state of New York is either a misdemeanor or a felony. You don't have to witness anything, right, in terms of assault in order to make an arrest. You get there, someone's got a black eye, everything leads you to conclude that person X did it. Person X is going to get arrested for assault, right? Just remember something. In New York, probable cause determines whether or not you can arrest someone, right? When you're talking about a misdemeanor or a felony, right? And if it's a violation, ordinarily you would have to have witnessed it, right? Then going down to the next paragraph, it says patrol officers usually make the first contact with the complainant or assault victim. Police on regular patrol sometimes observe an assault occurring. Usually, however, they are sent to the assault scene by the dispatcher. Assault calls are potentially dangerous for the police. And then skipping down, it says, furthermore, according to the FBI, more police officers are killed while investigating disturbance calls, and that means assaults, than while responding to robbery or burglary calls. Of course that's true, because you get there and people are heated up. They have weapons. It's tumultuous, to use a good word. And yeah, more cops get killed going to those types of jobs. We tend to think, robbery in progress is great. Burglary in progress is great. Yeah, you go to that bar fight, that family dispute. There was a young cop killed in a family dispute in the Bronx years ago, when I was on the job. Just a crazy, tragic story. During the family dispute, he gets pushed into a mirror. The mirror falls off the wall or something like that, breaks, and cuts a main artery in him, and he bled to death, right? So disturbance calls, very, very dangerous for the cops. More cops die going to those than to robberies and burglaries, right? And then down the bottom of page 319, it says, if people are injured, first aid must be administered or emergency personnel summoned to the scene. Yeah, I hope you remember that, right? Whenever you have an emergency response, you respond to someplace, right? What's the rule of thumb? Well, obviously, number one, if there's any threats to you, you have to take care of that first, right? You get there and someone's shooting at you, or they're assaulting you, or they're assaulting someone else. You have to take care of that. But if that doesn't exist, when you get there, you have to render first aid, right? Because you have your victims, and even your bad guys deserve prompt medical treatment, right? And then on the top of page 319 on the right, about 2 or 3 lines above the photograph of the woman in the hospital bed, it says the extent and nature of the injury determines the degree of assault to be charged. Make sure you take a look at that penal law handout. In New York, it's not merely the extent and nature of the injury, right? Remember, we have the PI, physical injury, and SPI, but it's also the culpable mental state and whether or not a weapon or dangerous instrument was used. Those things together, right? The nature of the injury, the extent of the injury, the culpable mental state, whether a weapon or a dangerous instrument was used, those things, those factors will determine the severity of the charge in the state of New York. Okay, let's flip the page. Top of page 320, it says the victim frequently knows who committed the assault, either by name or by an association that can be checked. Yeah, that's classic victim-offender relationship, right? And then skipping down a couple of lines, it says, if the victim of an aggravated assault is severely injured and indicates by words, gestures, or appearance that death may be imminent, obtain a dying declaration. And this is an interesting, I don't know how many of you are going to remember this, but do you remember the hearsay rule, right? And basically, what is hearsay? Hearsay is when one person wants to testify under oath about what somebody else says, and you want to offer it up as truth, right? And generally speaking, in courts in the United States, hearsay is not allowed. Right? We don't want people telling stories about what they heard someone else say and offering it up as truth, right? So we basically don't allow hearsay in criminal proceedings. But there are some exceptions to hearsay, the hearsay rule. One of them is res gestae. Do you remember that? RESGESTAE, res gestae. Also known as spontaneous utterances. You get to the scene of a bar fight, and there's a guy laying there almost dead, and the guy standing above him says, yeah, that's right, I did it, I killed him, so what? That's classic res gestae. He just blurted it out. You didn't ask him a question. You didn't ask him to incriminate himself. He just told you I did it. Res gestae is an exception to the hearsay rule. Courts, the judge will probably allow a bona fide res gestae statement. They will also usually allow a bona fide dying declaration, which is another exception to the hearsay rule, right? A dying declaration means you have a person in front of you who's The person's convinced they're going to die, and they make a statement to you about perhaps what happened to them, who killed them, who tried to kill them, who hurt them, who caused what's going on right now. If that person expires, or even if they don't expire, by the way, but if the court comes to believe that that person truly believed at that moment that they thought they were going to die, then they're going to classify the statement that they made to you as a dying declaration. And if they do that, if the court agrees, then that will be admissible, right? Just in the same way res geste is an exception to the hearsay rule, a dying declaration is an exception to the hearsay rule. Let's go down below that. It says the preliminary investigation. It says at a minimum, an officer arriving at the scene of an assault should, and then it says have backup either with him or her or on the way, control and disarm those involved. Yes, provide medical aid to injured people. Yes, separate suspects and witnesses. In fact, the book says separate suspects and victims. Yeah, and witnesses, I wrote in my book, right? Protect the crime scene, give Miranda warnings if applicable. Students always ask me, when do you have to give somebody Miranda? On TV, we give Miranda to anybody, anytime, right? They're going to go use the restroom, and we say you have the right to remain silent. It's ridiculous. In real life, right? When do we have to give Miranda to someone? We have to give Miranda to someone when they are in custody, meaning they can't leave, and we are questioning them. So, I have this little dumb mathematical formula. Custody plus questioning equals Miranda, right? And then it says obtain preliminary statements, photograph evidence, collect and preserve evidence, and reconstruct the crime scene. All true. Let's go down to proving the elements of assault, right? Look at learning outcome 4 in the blue box. It says, to prove the elements of assault, establish the intent to cause the injury, the severity of the injury inflicted, and whether a dangerous weapon was used. Yeah, that's true. We've talked about this. Remember, in New York, it's whether a weapon was used, right? This is, in other words, determining the severity of the charge, determining if a weapon was used, determining the culpable mental state, determining whether it's serious physical injury or just physical injury. Those factors taken together are going to determine whether it's a simple assault or a felonious assault, right? And it goes down below the blue box. It says establish intent. And then it says, and by the way, in New York, you just don't have intent in assault, right? We looked at it. Take a look at the handout. There's recklessness in there. There's with criminal negligence. So it's not just intent. And then it says at the bottom of page 320, establish the severity of the assault by taking photographs and describing all injuries in your notes, right? Yes, that's absolutely true. And an old trick with assault cases is you want to go back like the next day and take photographs of the injuries. Lots of times the injuries look worse the second day because they've developed bruises and things like that, right? So with assault victims, if we're going to build a case against somebody, we want to definitely go back. You want to take that set of photographs that night that documents the injuries or that day, and then you'd want to go back 24, 36 hours. You want to go back the next day, and you want to get a look and take some more photographs for your investigative folder, right? And then the last thing in that little section at the right-hand side of 320 says, determine the means of attack and the exact weapon used. Yes, because as we've been saying, that's going to be important. All right, I'm going to end part 1 right here. And, this is the way we do it. Make sure you have your notebook out. Make sure you're taking notes as I'm speaking to you. Don't just sit here and listen to us. Make sure you're writing just like you're in class, and you're going to be fine, right? And that's it. As always, thanks for listening, and I'll see you on the blog.